We're constantly being told that we should avoid probate. We should take steps to avoid probate. Very infrequently are we told how to avoid probate. But what if a probate is necessary? What assets are going to go through probate and what assets are not going to go through probate? There are many factors that have to be considered in analyzing each person's individual circumstance in order to be able to effectively answer that question as it relates to an estate you may be involved in. Generally, assets that are owned by the person who died, the deceased or the decedent, those assets that are owned by them are typically assets that would go into their probate. So some examples would be dad passed away and he had an investment account. Now, if dad happened to have designated a beneficiary on that investment account, then that asset would go to that beneficiary and not into the probate. Another example would be where spouses have a joint bank account and one of the spouses dies. Typically, by operation of law, the remaining spouse, the living spouse, would become the owner of that entirely upon the death. And so that asset would not technically be owned by the deceased at the time of their death and therefore would not go into probate. Those are what we call transfers by operation of law. Some common ways that assets are titled where they transfer by operation of law would be co-owned assets between married people or assets held with joint tenants of rights or survivorship. That's something you might see on real property like deeds, usually used with titling property that's not between married people, but it could be with married people. There may be assets that have beneficiary designations, some accounts. Life insurance is a classic one to understand where you designate a beneficiary to receive that insurance upon your death. And another one that's commonly used is payment on death or transfer on death. Again, usually associated with accounts, bank accounts, investment accounts, and things of that nature. Now, just because you have assets that are titled in one of those ways or many of those ways where they transfer by operation of law doesn't mean you shouldn't still also have a will. A will is important to protect against other assets they may fall outside of that category or a mistake gets made in titling assets. And while you may be able to avoid a probate by certain titling, if you need to have a probate, having a will in place is going to make that probate much easier and much smoother. Now, we have developed a tool for you to analyze whether a probate is necessary related to real property in the state of Florida. So we're going to drop in the description here a link to a website where you can use a free Florida Real Property Ownership Analyzer. That's at flprobate, flprobate.com. And you can pull the deed, answer the question there, and get an idea of whether a probate might be necessary for your particular situation. Now, that's only related to real estate ownership in the state of Florida. If you have other questions about estates or probates, please drop them in the comments because we're happy to do these videos answering your commonly asked questions in this area. Thanks for watching.